I'm changing my angle as the sun decides to come into my office. So good morning to everyone. Just kind of wanted to give a brief update on kind of the legislature. Not much has happened since the last time we met in August. When the session ended at the end of June, a working group was put together to kind of work on collectively get an agreement to give some frontline worker bonuses out, and in hopes of coming back for a special session in September. There's 9 people appointed to this working group, and they have not come to an agreement, so there has not been a special session. Other hangups on the special session were also that the governor was hesitant to call one in fear that the Senate would choose to not confirm Commissioner Malcolm, the Commissioner for Department of Health. And so he really didn't want to bring them in for fear of losing her. And then other things were added to a possible special session, being mask mandates for schools, some drought legislation. So there's a lot more things than just kind of frontline bonus worker language. So also coming up has been a lot of hearings on redistricting. When the legislature ended in June, they set the January 31st start of session in hopes of having redistricting lines drawn. There's a February 15th deadline for when the lines need to be redrawn for the 2022 elections. We will also find out at that time who will choose to run and who will choose to not run next year. In the last 40 years, there has been no consensus on the redistricting line, so it has been thrown over to a court panel to decide and to draw those lines. The court panel has already been appointed. They have already started having hearings. They've already started to looking at all the data. So while there are redistrict committee hearings being held in the House and the Senate, the courts are also doing their due diligence on their side. Their hopes are that the legislature will come to an agreement by February 15th, but they will be ready regardless if that deadline is not met. 99.9% chance that that deadline will not be met by the legislature, and that we will have the court lines drawn by them. At the end of September, the House Commerce Committee had an informational hearing on a privacy bill. Representative Elkins from Bloomington introduced a bill in May of 2019, which was mirrored after the California privacy bill. Over the last 2 years, he's changed it quite a bit to a Washington state draft legislation. The bill has not actually passed in Washington state, but Representative Elkins is really focused on that state's language. Did testify at that hearing on behalf of the Minnesota Bankers Association, and really testified to the need for a Gramm-Leach-Bliley entity exemption. There is a Gramm-Leach-Bliley information exemption in there, but looking for an entity level, and really stressed that banks have been following privacy regulations for decades and are the only industry that is currently being examined for those regulations. And so there really is no necessary reason for us to be included in this bill. There is also an exemption in the bill for data over 100,000 consumers. So it will really take out a lot of the community banks. Big information for this week, and I'll just touch a little bit on this, is the elections. It's a odd year for elections, so it's really the municipal elections that are happening this year. We did obviously see things on the East Coast that really did kind of point to what 2022 will look like. In Minnesota, you may have seen a lot of school boards were being much more vocalized, and much more attention on school boards than I've ever seen. Also, in there was also, I think most of the focus was on Minneapolis. What was going to happen with Minneapolis? Public safety has been obviously a huge issue for the last 18 months. Really watching what was going to happen with the charter amendment number 2 in Minneapolis, which was voted down. One thing to be very aware of is that while the amendment was voted down, and that nothing technically will change based off of that amendment failing, 43% of the voters in Minneapolis did choose that they wanted a change in the public safety department in Minneapolis. So that is something that they need to be aware of, and how that's going to come about in the next couple of years. 7 new city council members were elected to a 13 panel of city council members in Minneapolis. So they have now, it's a a lot of new people again this year. Mayor Fry was reelected, which I think shocked a lot of people after looking at a year ago and kind of how things were going to be playing out, that most people believed that it was going to be really tough for Fry to win again this year, but just with some of his opposition and the opponents, he did easily win that race. One thing in Minneapolis and St. Paul was both cities had rent control amendments on their ballots. In St. Paul, the amendment that did pass caps the rent control at 3%. In Minneapolis, it doesn't put a number on it, but it gives them the ability to impose rent control. They would have to have much longer and further discussions for Minneapolis to do it, but St. Paul is definitely going to move ahead with it. I say this more because we start looking at what next year's elections are going to look like. The legislature will be in, they will have a surplus next year, so they are going to have some money to spend. There will be a lot of policies that they're going to look at next year, but really kind of looking at a year out, the three big issues that will play in the election next year are public safety, the economy, and education. Those will be the three main issues, I believe, that will be all encompassing of the 2022 election. When we meet again in February, it will be right after session starts, and so I will have a lot more information. One thing that we are starting to do right now is we are having conversations with the governor's office and the Department of Commerce and the House and Senate on legislation for the 2022 session. We are always interested in what bankers and others are interested in us doing proactively. We do a lot of defense. If there are any old regulations on the books that you are, or things that need to be tweaked, we always are looking for more ideas, being more proactive at the Capitol. So feel free to send Tess or myself some language or ideas of what you might want to look at in the future, whether it's next session or going forward. But we are here to help any way that we can. So with that, Tess, I will hand it back to you.
Teresa, I know this is a federal issue, but people are really interested in that IRS reporting proposal. Could you give an update of where that's at?
Yes, and Renee did drop in the chat for everybody a link to sending letters into the House and to the senators in Congress. We've been working diligently since this issue came up a couple months ago. We've reached out to all the members of Congress, all of our senators. We've had conversations with them in person, on the phone. We are fingers crossed that it is gone. The last we have heard is that it's no longer being included in these bills, but it's gotten a lot of traction from bankers, from your customers. I was out trick-or-treating with my daughter's friends the other night, and the mom brought it up to me. So it's definitely something that's on everyone's mind. Nobody wants their information sent to the IRS. While we are very hopeful that it will not be included in any future draft of their spending and reconciliation bills, that doesn't mean that we shouldn't still reach out. So we appreciate everybody that has reached out to their House members and the US senators. The link is in there. If you haven't yet, please do it. We just want to kind of make sure that we don't slow down any momentum if they do decide that it will be a good idea. So.
Okay, great. That's good news. That was pretty scary for a while there.
Yes.
It wasn't looking good, but all those letters, I think there was hundreds of thousands, right?
Yes, there are hundreds of thousands. And, Congressman Emmer he had written 2 letters and gotten a lot of more Republicans to sign on to those. But I think the big thing was towards the end was when 21 Democrats wrote to the president saying that they did not want this to be included in any bill. So I think it was really kind of watching it cross the lines and knowing that there were some of those moderates that they really did need to get this over the finish line that weren't going to be there for them. So.
Okay, that's great. Thank you. We just had someone ask if they said they're having a hard time hearing Teresa, that it's cutting out. I'm not having any issues and we're not in the same location. So I'm hoping it's just you and I hope it improves. I want to turn it over to Tom now to talk about deposit accounts and safe deposit accounts when people pass away. Tom?
I can turn on my video. We get going. All right. Good morning, everybody. Yes, moving on to the much more uplifting topic of deceased customers. I received a few few questions about that and talking about deposit accounts as well as safe deposit boxes because they're treated somewhat similarly. But I just wanted to start off by talking about if you have a deceased customer. What I'm talking about here is either an individual account or the last remaining joint account holder. Obviously, if there is a joint owner on an account, everything just transfers to that remaining joint owner. So you don't have any special activities with the deceased former joint owner now. As well, if you have somebody who's an authorized signer on an entity account and they die, that just goes away. The entity continues on. Their entities don't die in the same way that a person does. So they'll continue on. Even if you have a single member LLC, something of that nature, where it's really just one person that's functioning as the LLC, still the LLC continues to exist even if the person has died. So there should be some mechanism in the LLC documents, hopefully, to account for that death if there's a successor person for that LLC. Otherwise, you're dealing just with estate-related issues. Also, if you have on the deposit side, if you have a payable on death beneficiary, you just want to make sure that you have verified how the payable on death is set up. Typically, it's just going to be equally between however many beneficiaries there are. But it's possible that some banks have had, set percentages per beneficiary. So you just want to make sure you're following whatever's been set up. And that's just on the deposit side. Obviously, if you have a safe deposit box, you don't want to have any payable on death beneficiaries on safe deposit box. It's not something you can affect through the safe deposit box lease. So if you have payable on death beneficiary, it may be helpful to contact those individuals and say, we can't, this is a nullity, so we can't enforce it. So they need to make other arrangements for something of that nature. Okay, but as far as deposit accounts, just generally, once you get notice that a customer has died, then it starts to trigger some statutory requirements as far as what you can pay. You do have to get some sort of notice. You have to know that the customer has died. There's some flexibility there on whether it's actual notice or constructive notice. If you have a process where you have an employee that's looking through obituaries, things of that nature to learn about deceased customers. If you do have a regular process like that, it's possible that you could be assumed to have known about the death, even if you don't actually know about the death. But you need to get that. You do have the ability to pay checks, with checking accounts if those items were written before the account holder died. And then, nobody who has a claim, able to make a claim on the account, has informed the bank to stop paying those checks. But, you can pay those items up to, under the statutory scheme, up to 10 days after death as well. Something that also comes up too is power of attorney. If you have a power of attorney on a customer, once that customer has died, that's granted the power of attorney ceases to exist. So those attorneys, in fact, don't have the right to go in and conduct transactions on the account. And it's really similar in the safe deposit box framework. Although you're not paying items and there's no access, it just stops on there. But you do have you have a similar sort of framework where somebody can access the safe deposit box just to do an inventory. That's typically going to be in the small estate affidavits. If you've got $75,000 or less, and that's total assets for the estate. So that's something that's going to be stated in the affidavit itself, and the bank doesn't have to go in and verify the truth of that information in the affidavit. You can just accept the information that's in there. But generally, you have the small estates. There has to be 30 days since the death of the individual. You get a certified death certificate, that type of information, along with the affidavit itself, identifying somebody's claiming that they have the rights to it. So in the deposit account, once that occurs, then you can potentially pay out the funds to that individual. For the safe deposit box, then you're granting them the ability to do an inventory of it, where the bank goes through with the person and writes down everything that's in the box, and you sign it off, and then they can later do potentially claim whatever's in there, if there's anything in there. Let's see, one thing too that comes up periodically, that is if when you're finding out about a customer that has died, and you're talking with the alleged personal representative, one thing that is just to clarify that they're a court-appointed personal representative as opposed to a personal representative that's named in a will, because the court-appointed personal representative stands right in the shoes of the deceased owner, so they can take all necessary actions, whereas somebody who's a personal representative who's just been appointed by the will, they cannot. So you do have to wait until the court appointment comes. Let's see, I think the last thing I really wanted to talk about too was another item, a question you get about if you have an individual that dies and they're under a conservatorship or guardianship, something of that nature. It's similar to POA, where it ceases to exist upon death. So the court would need to appoint a new conservator or a guardian in order to conduct a business on the account or the safe deposit box. So you would have to wait for that kind of new court appointment. It could be the same individual, but it would be a new appointment from the court. So not the existing one that covered the person while they were still alive. And I think that's what I wanted to cover. So hopefully that's some helpful information. I'll throw it back to Tess.
Well, Tom, I think a lot of that is you follow those rules because they protect the bank, right? So we get a lot of questions about, let's say someone comes in with that affidavit and you're like, really, I'm pretty sure there's a closer relative, or I'm not sure that you're going to share this with the other relatives or whatever, but the statute protects banks there. They don't have to police that and make sure it's the right person,
Right.
But that's about protecting the bank. And same with doing the inventory on a safe deposit box. That's how
Right.
you're protecting yourself from liability. Same with only talking to a personal rep who has court appointment, and has those papers to show you. That's how you protect the bank from liability.
Right.
Because those situations where you have other heirs potentially are, of course, an area that has a lot of litigation if someone thinks they're entitled to something and didn't get it. So that's why it's extra important in death situations, don't you think, Tom, to follow the rules?
Yeah, it's very important. Yeah, to be conservative in how you're dealing with that. And not just other individuals too. We got medical assistants can make claims on deceased accounts, both safe deposit box and the deposit accounts as well. So they can actually make claims on those funds or property as well. So.
All right, thanks, Tom.
All right, thank you.
So I want to talk about the vaccine mandates that all came out in September, because the new rules were issued yesterday. So President Biden's administration had rules on federal contractors, and there was concern that banks would be considered federal contractors. Hopefully you've seen the bulletins we've issued, legal compliance bulletins. If you don't receive those, you can look on our website and you can register to receive those. But after looking at all the information on that, we think that banks are not federal contractors for the purpose of that vaccine mandate. So the one that banks really need to be concerned about is the one that applies to employers with 100 or more employees. And we've been waiting for rules on that. There's an emergency temporary standard. I have to pause for a sec because someone has a question about deceased accounts. And I don't see okay. She asked if someone dies and their account is still open, the POA receives a check in the name of the deceased. Can they deposit funds into the account? And what do they write on the back of the check? Okay, so the person has died. They had a power of attorney. We know that power of attorney is no longer effective, but they have that check. So can they deposit into the account? So a lot of this stuff is, when bankers ask me these questions, I say, how much is it? Because, risk depends on how much money we're talking about. But a POA wouldn't have to sign that check. I mean, if you're depositing into the check of the deceased in the first place, you don't need a signature on the back. So you could accept a check for deposit. Especially if it's real close to the date of death. There are banks that will accept checks in small amounts because that they know the risk is low. So, I mean, there isn't like a black and white answer that says, oh yeah, that's fine. But when we're talking about relatively small amounts and maybe the customers, Tom, do you have something on that?
Yeah, it's the same thing. There's not a black and white answer there. I think it's better if the check is written before the person's deceased. There are some banks that would be very conservative and require, well, the person's dead, so we can't accept the check now because the account is essentially frozen and held, and they're, have the person go back and request that whoever made the check make it out to the estate now, and then wait for that to happen. That can cause problems too. If it's a small estate, there may not be an actual estate as well. But yeah, it's just, as Tess said, it's just a matter of risk, what sort of risk you deem there may be attached to the transaction and whether you're willing to accept it.
Yeah, and I do think that a person could use that affidavit of small estate to negotiate a check. I've looked into that pretty closely. And I think that the statute does extend to a check, not just to a bank account itself. So it's possible they could use that to negotiate that check. There isn't any, it doesn't say that specifically, but it's pretty broadly worded. So I do think that's the case. So.
Yeah, it seems to cover any kind of property, and the check would be a property of the type. So.
Yeah. So that's another option too. All right, back to vaccines. So the OSHA just published rules yesterday. So we've been waiting for those since September. This is applying to the 100+ employers. So the rules came out and they are giving until January 4th to comply, which is good because sometimes when they issue these things that they expect compliance really quickly. The MBA offered a webinar on this topic, and the lawyer who did the presentation gave us all the materials from that webinar to provide free to our members. So those are all on our website. If you just put OSHA toolkit on there, you can get all that information. So under this rule, they call it a vaccine mandate, but it's really not. It's a testing mandate that is hopefully pushing people into getting vaccines. That's what the Biden administration wants. So under these rules, you do have until January 4th to comply, but all unvaccinated workers have to begin wearing masks by December 5th. And then they'll have to start providing negative COVID tests on a weekly basis after January 4th. One surprise in these rules is they're not requiring the companies to pay for or provide the tests. Experts thought it was likely that the employer would be responsible for that. Anyone who tests positive is, of course, prohibited from going into work. So companies also have until December 5th to start offering paid time off for employees to get vaccinated and paid sick leave for them to recover from any side effects. There's already been a legal challenge. I'm sure you've heard about this. I think probably all of the Republican attorney generals across the country are filing a legal challenge. Now that the rules have been issued, we'll see more. There's 40 Republicans in the Senate that are planning to use the Congressional Review Act to challenge the emergency temporary standard. So the reason that they're challenging it is they're saying that this isn't like a grave enough situation that it's appropriate to force this on employers. And a lot of experts do think those challenges will be successful, but we're pretty conservative here, I suppose, as bankers and lawyers. We think banks should be prepared to comply with this. I mean, we hope it won't be necessary, but I mentioned we have that toolkit, and then OSHA is also going to be providing sample implementation plans and fact sheets and other materials to help adopt the rules. When we look at the 100 employee threshold, so someone just asked that we confirm that this, so I'm talking about banks that have 100 or more employees, but if you have like a bank holding company structure, or common ownership, common management, some of those can be then lumped together. Those employees get lumped together to get up, could get you up to 100. So what you need to look at experts are saying is your EEO1 form. If your bank is filing that, and your HR person will know if you are, that's a mandatory annual data collection requiring private sector employers with 100 or more employees to submit demographic workforce data. So if your bank is filing those, then that's a good sign that this applies to you. So again, starting on January 5th, all unvaccinated employees will be required to be tested weekly for COVID. So it isn't specific. I don't think that it has to be done on Monday or anything like that, but it has to be done weekly. So this is not a vaccination mandate, and it doesn't apply if employees are fully remote. So remember that if you have somebody that's remote that week, they wouldn't need to get tested that week, as long as they're not coming in at all that week. There are religious practice and disability accommodations, but it's pretty much of a stretch to apply that to testing, because that's really what we're talking about. Your religion doesn't allow you to get tested for COVID. That's more of a stretch than the vaccine. As I said, employers don't have to pay for the vaccine, but they are supposed to give time off for getting vaccinated and any kind of time for recovery from side effects. OSHA has said that approval for employees to use sick leave, PTO, vacation, et cetera, is sufficient. So it's not like you have to do a special pay for that. You can require them to use their sick leave or PTO or vacation. If an employee refuses to do the weekly COVID testing and they're not vaccinated, then they can't come to work. So they actually would need to be on probably an unpaid leave of absence or terminated. Other companies have done an unpaid leave of absence until the rules change. So that's an option. OSHA says it will conduct on-site workplace inspections to make sure that companies are complying with the rules, and the penalties for non-compliance can range from $13,000 to $136,000 if you've got a company willfully violating the rules. But the fact is that OSHA only has a couple thousand inspectors nationwide, and there's no mechanism for checking up on these millions of workplaces. So I think this is going to be really driven by complaints. We have a question about where to find that toolkit, and it is, if you just go to the search box and just put OSHA toolkit, it will pop up. That was the easiest way to find it. We could change that and put it somewhere else, but I guess that was a big deal. So I told them you'd be fine with putting in OSHA toolkit on the top. So we'll see. Anyway, so that's the vaccine mandate. So I would just make sure if you're part of a holding company or something, check on the EEO1 if you're not sure if you are under that threshold or not. If you're under that threshold, you don't have to worry about anything, because we've really gone through the federal contractor stuff, and it doesn't look like it applies to banks despite FDIC insurance or working with the SBA or Fannie Mae or any of that. So unless something changes, it would not apply. The federal contractor stuff wouldn't apply to you. I think we got one more question in there. Check it out here. How about if a check, we're back to people who are deceased. How about if a check is made out to an estate and there is not an intention to have an estate account set up? Does the bank need to cash a check with the affidavit? I would say no. I mean, that check's made out to the estate now. They need to get that reissued or open an estate account. I know everyone is always trying to avoid that, and it is a lot of rigmarole, but that's not made out to the person. It's made out to their estate. And it seems like more of a stretch to say that you could use an affidavit with that until we have a court case on that. I mean, we don't know for sure, but I would say that is going a little bit too far. Okay, I think we have filled up our time here. Thank you so much for joining us today. I think next time we meet, we'll be getting more information about what's going on in the legislature. And if you have any ideas for topics, you could just send those to me at tessr@minbankers.com, anything you want to hear us talk about, and we'd be happy to do that. So thank you so much for joining us today, and have a good rest of your day. Bye.